Another defense would be lack of standing. The defendants can argue that the plaintiff does not have proper standing as a shareholder or a member, perhaps because they were not a shareholder or a member at the time that the wrongdoing took place. Also, if a shareholder or member does not make the demand upon the corporation or LLC, and they do not show that there is futility, then the case could ultimately be dismissed because these are stringent standards that need to be in place prior to the initiation of an action unless there is that futility. The corporation shareholders may ratify the alleged misconduct, and that could potentially preclude the claim from moving forward. In scenarios where shareholders have gripes with the business, if it doesn't arise to fraud, if it's not egregious and severe, and a majority of the shareholders ratify the conduct even if certain shareholders didn't feel it was right, ultimately that may preclude the ability of the shareholders to proceed in a derivative action. Because once again, the courts want to see companies self-governing, they do not want to meddle too far. However, when there are claims of fraud or something severe, something highly detrimental, then even if the majority of the shareholders ultimately ratify conduct, that may very well not be enough to preclude a claim under a shareholder derivative theory of liability. Derivative claims in New York generally follow the applicable limitations for the underlying causes of action, whether it's a breach of contract, whether it's a fiduciary duty, or associated claims. The statute of limitations that otherwise provide for a limitation for when you can bring a case ultimately do extend to derivative actions. Ultimately, as time goes on, shareholders may become disgruntled and they may seek to initiate an action. Now, a big component that we've seen of late, and what the courts have touched upon in various cases, is that it's just one shareholder. Well, one shareholder can bring a derivative action on their own. However, it's often far more helpful when multiple shareholders come together or a fortified front and are moving together, because the court will take this into consideration to really consider the extent of how bad the alleged conduct truly is.